Hello, my name is Marvin. I'm currently a 2L and a staffer for the Minnesota Journal of International Law. Today I'll be having a conversation with Professor Fionnuala Ní Aoláin. Professor Ní Aoláin is a University Regents Professor, holder of the Robina Chair of Law, Policy and Society, as well as working as the Faculty Director for the Human Rights Center here at the law school. She spent 6 years working with the United Nations as a Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. Earlier this year, she was appointed to the Honorary King's Council by His Majesty the King of England, which is a lifetime appointment. She has received numerous academic and research awards and honors and is a world-renowned and respected advocate for human rights and a scholar of international law. Thank you so much for sitting down with me today, Professor Ní Aoláin.
Thank you.
I was hoping we could start with a little bit of background and you could talk about how you ended up working for the University of Minnesota Law School and what type of work you were engaged in before your tenure here.
So I came to Minnesota in 2004 and I came as a lateral hire. That meant that I was already, I suppose, an established professor. And I came from Northern Ireland. I was a professor there. I was running a small research institute on post-conflict and transitional societies. And my predecessor here at the law school, David Weisbrod, who I think had the foresight to see that he might need a successor, I think was chair of appointments, actually. So he was one of the reasons that I ended up here. But I was also lucky. My husband is a faculty member, and one of the things that the University of Minnesota does very well is hire couples. So we came together.
Great. So during your time here in 2017, you were appointed to serve as the Special Rapporteur with the United Nations.
Yeah.
Can you explain kind of big picture what this position entails?
Yeah. So that role is one of the special procedure mechanisms, which is an appointment by the UN Human Rights Council. It's a political appointment, so you're appointed by states. And I had been doing a lot of sort of global human rights work in the years before, but probably most relevant, I had spent 5 years between 2000 and 2005 on the National Human Rights Commission of Ireland, post or Good Friday Agreement, peace agreement signature, which meant that I sort of had a long-standing relationship with the Irish government. And generally, although it's not required, you need a government to often help you in these processes of appointment, global appointment. So I was encouraged to apply for that role by the Irish government. And obviously, the Irish government supported me in the political horse trading that happens around these things. The role has sort of three sort of capacities. I wouldn't call them powers because they're not, you're still very much you're working around state privilege in an international system. You can visit countries. So there's country visits, which allow you, when a country invites you, to come and assess that country's compliance with international law for me, in the space of counterterrorism and security. You can issue communications to a government. So if a government is committing what you believe to be serious or systematic human rights violations, you can articulate your concerns to that government through a formal letter or communication. And we always had way more sort of communications or requests than we had capacity. And then twice a year, you give a report to the General Assembly and the Human Rights Council. So you issue reports on issues that you think are important. So, but the role is a political role. Those are the formal powers that you have. But a lot of your time is spent actually as a diplomat. You spend a lot of time talking to states, working within the UN system with different entities, UNICEF, UN Women, the Office of the High Commission for Human Rights. And so you're spending a lot of time trying to do a lot of things that are not so public, but are actually about trying to move state compliance in a really sensitive area, because for many states, security is their most sensitive issue. And it's the place where it's often hardest to dialogue with states about what the implications for human rights are.
A lot of or part of your research in this role regarded how counterterrorism is used in the name of stripping human rights advocates of these powers. Can you talk more to that?
Yeah, I mean, I had spent a lot of my life, you know, I finished law school, I did a PhD, I went to teach, but I was always involved in sort of both local and then regional and then global human rights issues. And I'd always seen myself as part of civil society. I see academia as part of civil society. And one of the things that was really clear to me, both in my prior work, but also then as I started traveling in my UN role, and I would always meet with civil society in country where I could, and where it wasn't safe for them, I would meet civil society outside in countries that were very repressive, where there would be dangers for them to meet with me. But one of the things that was really clear to me, and I think became clearer as I was Special Rapporteur, was that the impact of securitization, but also sort of hard, kinetic counterterrorism, as well as what I would call softer assemblages and structures and norms, soft norms of counterterrorism and countering violent extremism, were particularly being used by states against their civil society actors. So one of the things I started when I first went before the Human Rights Council and I talked about what my priorities were going to be for my 6-year term, I had placed civil society pretty much at the heart of all the work I was doing. And so that meant meeting with them in country. It meant ensuring that in every report I wrote, whether it was on technology or whether it was on institutions or whether it was on drone strikes or whatever it might be, I was elevating the costs to civil society. And I think the culmination of that work was in my last year as UN Special Rapporteur. I was really fortunate that I had 2 governments, the Federal Republic of Germany and the Kingdom of Spain, who were prepared to support me to do a global study on the impact of counterterrorism on a civic space. Mm-hmm. And so we were able to support that out of the Human Rights Center here at the law school. We had a team here that enabled that study to happen. And we sort of just crisscrossed the globe for a year, and it was bringing together all of this work to really identify what the global patterns of misuse were against civil society.
Part of your mandate was doing country visits. So during your time, you found your way into places that few human rights activists and lawyers are allowed. Yeah. So first, I'd like to talk about your time visiting detention camps in Syria. Yeah. Even gaining access to these camps was quite a monumental step. Do you see any positive path forward for these camps, such as their humanitarian aid or organizations coming in, such as the UN?
Yeah. So Syria is and was a really complex file for me. Pretty soon after I became mandate holder, Raqqa had fallen, so the caliphate had been formally sort of vanquished, although I think that was a pretty premature vanquishing. But at least the global coalition against Daesh had declared victory against the caliphate. But one of the offshoots of that was that thousands and thousands, mostly of women and children, but not only, people had fled these enclaves, which had been under the control of these designated terrorist groups. And they had found themselves in what were being called camps. And early on in my mandate term, mostly I was trying to get information on what was happening in those camps. And there was almost no information getting out. Syria was inaccessible. The other states who were proxy fighting or actually on the territory were certainly not talking about what was happening. And you had several non-state armed groups, including the Syrian Democratic Forces, and it was the SDF that were in control of the camp. So early on, my single major goal was to try to get information about what the scale of detention was, what the conditions of confinement were, and what legal framework, if any, was being applied. So who was there and what was happening to them. And so that was really difficult. And over the course of several years, we gained the trust of several of the key actors, including the states on the territory. And those are a complex group of states. Obviously, there's the territorial state, which is Syria, the Syrian Arab Republic. But the United States has a military presence on the territory. Turkey has a military presence on the territory. Iran has a territorial presence, as does the Russian Federation. So to do any work in Syria, you had to go through and engage with all of these actors, and of course the non-state actor. So and then there was a sort of a really important question of engaging with the Syrian government, which at the time several human rights actors felt strongly that that was a very problematic thing to do, that it might involve normalizing a state that many other states were essentially putting into sort of purdah. So I made the decision sort of 3 years into my mandate that it was really important, and it's my general view that you engage all the actors, even the actors who are really problematic. And for me, that's often meant engaging states who are viewed as problematic by the international community, and also non-state groups. And that's also quite complicated. So we started a negotiation to get access to the territory, and that, I would say, it took 6 years, more or less, and the long and complicated story about how we managed ultimately to convince the territorial state and the non-state actor, and not have any of the other states block the visit. And so I was in northeast Syria last July, and I issued both a General Assembly report and an end of mission statement. I estimated at the time that there were 73,000 people in detention. So this is the single largest detention facility for children anywhere in the world, and there's no exit and no legal process. And the conditions of confinement are in absolute and systematic breach of international law. Do I see a solution? The solution is that states would bring their nationals home, including the U.S. U.S. has had and has small number of, still has nationals in those camps. And frankly, Western and other states, so democratic states, have been deeply disappointing. Canada, Australia, for example, the United Kingdom have simply refused to take their nationals home. So we have a minimal humanitarian presence there. It's not enough. And as this interview is being recorded, just a couple of days ago, we had an attack on Aleppo, and non-state forces have again taken over Aleppo. So those detention sites are really precarious. And my big concern actually is that we're going to see a reignition of the war in Syria and catastrophic humanitarian consequences, actually. Yeah.
Do you feel that there's any international frameworks that could step in to try to force these Western countries to take their nationals back, or is there anything that can be done at this point?
So I think a fair amount. The best route, the forcing route, so there's sort of non-obvious routes, which is dialogue with those states, which is what I and others spent many years doing, which is trying to convince those states that it's not just a good human rights practice. That's a good thing. But actually their long-term security interests lie in bringing their nationals back. And sometimes for me, in the role I was in, of course, I would make a human rights argument, but sometimes that's actually not the argument states are going to find appealing or useful to them. And here I think the sort of strategic security argument is really important. And one of my best allies in a lot of this work were actually the military and intelligence services of many countries, who also took the view that leaving a large population of their nationals in a territory like that, it's sort of a ticking bomb exercise. If you leave people in those conditions, then you can guarantee over the long haul, just as we saw in Raqqa, that people will view alternatives, including designated terrorist groups, as a kind of savior or support in a context where their own governments have failed to step in. But dialogue has only got us so far. And the other route is litigation. So when I was in mandate, we were engaged in a lot of litigation, and we supported several families in different jurisdictions to litigate, providing technical assistance, but also amicus briefs. So for example, in Canada, one of the ways that Canadian families managed to get some portion of their family members back was going to the courts and arguing under domestic Canadian law that the state had an obligation to return its nationals. So we've done okay. We've had some European case law. We've had Canadian. We had British case law, but it's not enough, I would say. It's just not enough. We need a political solution, not a legal solution to the problem.
Another detention area that you visited during your time at the UN was Guantanamo Bay, and it's unheard of for human rights activists to be allowed in to speak to the prisoners. Can you explain, was this visit harder to come by than your visit in Syria? What type of red tape did the U.S. put you through in order to gain access?
Yeah, I mean, I would start by saying, like, prison visits are always really sensitive. So the mandate I held is a mandate that had when we undertook visits, we always did prison visits. And I would say that when I was negotiating with any state, I visited France, I visited the Maldives, I was in multiple countries. And to say, like, the prisoners I would be seeing are all high security prisoners convicted or pending under process for terrorism or other serious crimes. So these prisoners are often limited in their access generally, either to lawyers sometimes, but also to the outside world. And they're viewed as very dangerous prisoners. So often, I think, and maybe this is somewhat gendered, when you show up as a woman special rapporteur and you say, oh, well, I'm going to interview what you think of as your most dangerous prisoners, there's a fair amount of, I would say, chauvinism about your capacity to actually do that. But I've been in and out of prisons, with high security prisons, since my earliest work in Northern Ireland as a young student lawyer. So with Guantanamo, it was really complicated. I have had a long-standing interest in Guantanamo. I've written a book on Guantanamo, on military commissions. I had worked closely with some of the lawyers who were taking cases in the sort of early 2000s. And so when I became SR, I was really clear that Guantanamo was unfinished business for the mandate and for the international system. And I first went in the fall of 2017 to then speak to the Trump administration, which was the executive, to ask about access. And, you know, one of the things I would say is that my mandate had very good relationships with human rights actors, but the other set of relationships were with security actors. Like, the work can't be done. That is actually your primary audience. And so the start of that conversation was clearly not that they were going to give me access, but it was about starting a conversation. And that conversation, again, also was a 6-year negotiation. I traveled regularly to Washington. It required an interagency process, so it had to be, and it required sign off by the National Security Council and the White House. And I would say, you know, the barriers were that there had been a practice established by the US not to allow access to the detainees. And so you have to sort of demonstrate some things. One is that you're not going to harm, because it's not just the government you had to convince. You had to convince the lawyers who had the best interests of these men at heart that we were not going to do harm to the men. I mean, imagine that you haven't had access to anybody, maybe except your lawyer, in a very particular way, and then this group of people show up in blue UN vests. You know, that's also the harm works the other way. Mm-hmm. And I think we also had to establish trust, because the Guantanamo visit was part of a 3-pronged visit. The other part of the visit was with the 9/11 families, and the third part was with detainees who've been repatriated or resettled to other countries. So these 3 pieces were interlocking. By demonstrating, as I think I've always demonstrated, an enormous commitment to victims of terrorism, the 9/11 families understood what the purpose of the visit was, that I had some business with the US government about their failure to fully treat the victims of the 9/11 terrorist attack appropriately and in compliance with international law. So it wasn't just one piece of the puzzle that pulled it together. Was it more difficult than Northeast Syria? I don't know. It like a different kind of difficult. But I also think that because I was doing these multiple negotiations with states at sort of parallel, we had a lot of experience. I had a very experienced team of women lawyers. Actually, all my lawyers I had a phenomenal team of legal experts. And we were all very good at understanding how to triangulate relationships. So it wasn't just my relationships, but my team were building relationships across all these actors and with different parts, including of the US government. Yeah.
Sure. So you've said many times that the first thing human rights advocates smells when they visit a prison is paint, because
somebody's cleaning up.
Yes. And you also talked about how there was a gift shop at Guantanamo Bay.
Right. Yeah.
So I'm kind of curious, how does this sort of welcome that they've created for you juxtapose with the actual work that you're there to do, speaking with the prisoners?
Yeah. So I would say the fresh paint phenomena tends to be in prison systems that are really historically quite decrepit and old. So I'll talk about two reports where I've talked about the fresh paint. One was in Kazakhstan and one was in Uzbekistan. And in that case, these are prisons that, in both cases, where there had been significant international criticism of the prisons for a long time. And I mean, on the one hand, I don't think that's a bad thing, right? Because actually sometimes the thing a special rapporteur visit does is it cleans up the prison. So you may not be able to change the fundamental structure just by showing up, but the fact of your arrival means that everybody in that prison is focused on making sure the drains have been cleaned, the rooms are painted, that the toilets are functional, because we also inspect toilets, down to the toilets we inspect them. And so actually the conditions of confinement improve by allowing access. And I'm sometimes cynical about the paint, but I think the paint is actually not a bad thing in itself. You know, I would say about Guantanamo, as my report indicated, the conditions of confinement at Guantanamo have improved enormously since the first prisoners were transferred there. They are no longer in Camp X-ray, which was a sort of a set of cages and orange jumpsuits that people have seen. And that wasn't where actually I found the most grievous violations by the US government. The conditions of confinement, the quality of this prison as compared to many other prisons I've visited is high. It's very high. It meets international standards. The issue is the absolute arbitrariness of the prison. The fact that there are 16 men who are still today, who've been cleared for transfer by PRBs, told they are not a threat to the national security of the United States, that they have committed no crime, and they are still being detained by our government. We have 3 so-called forever prisoners, 3 men who have not been charged with anything. And the idea of forever prisoners is fundamentally inconsistent with a democracy. Democracies do not have forever prisoners. That is Kafkaesque. It's unacceptable. It's simply an egregious breach of the rule of law and our Constitution, if our courts would ever get around to addressing the fact, which they have miserably failed to do. And maybe just to say about the gift shop, you know, part of that speaks to the normalization of Guantanamo. Guantanamo is an exceptional place. It was created outside the law. It was intended to be outside the law, and it's normalized. And Guantanamo is also a naval center, so that it has other functions. But it's pretty strange to walk into a place which the world finds synonymous with torture, rendition, waterboarding, breaches of the rule of law, and be able to buy flip-flops and a t-shirt that say, there ain't no place like Gitmo, right? So that's a sort of the commodification of that, I think, makes many of us really uncomfortable. Yeah.
So you mentioned that you and your team were likely the first people that these detainees had seen, aside from their lawyers and the prison guards, in a long time. So I'm curious, were the detainees willing to speak with you? Were they afraid of retaliation? Did they trust you with their stories?
I mean, I think that when you meet prisoners anywhere, you know, they have every reason not to trust you. Well, first of all, in the context of these prisoners, but others, they don't necessarily believe that you are who you say you are. In highly repressive systems, governments send people in that they say are doctors, and they turn out to be intelligence agents. And of course, we know in Guantanamo there was a long history of the state using individuals who prisoners were told were in one role, but were actually performing an intelligence role or a coercive role for the state. So trust is a really huge issue. I think our really long-term relationships with the lawyers who see their clients pretty regularly helped that, where their lawyers were able to say, these people are who they say they are. But also, it's a huge, your biggest worry when you go into those kind of meetings is that you're going to do harm to somebody. Because you show up with your blue vest, and on the one hand, I don't I accept that the symbolic significance of UN vests, and we made a decision as a team that we wore our vests everywhere on the island. So generally I only wear my UN vest when I'm walking into a detention facility or somewhere I'm on an active zone where someone needs not to harm me, and they know that I'm protected by virtue of the vest, at least theoretically. But we made a decision as a team that everywhere we went, on the buses, when we ate in the mess, when we, there's an Irish bar at Guantanamo, so we wore, because we were trying to signal that the UN was here, right? The UN was here, and that was important for just regular soldiers who are guard force doing a rotation from the National Guard of Minnesota, for example, would see that this is a place where the UN shows up. But for the detainees, seeing a vest might say, I'm going to get out of here. The UN has showed up. I'm going home. And of course, since I left the prison, 4 men have been transferred. So there were 34 when I visited. But there's been no mass release of the detainees, which was one of my recommendations. Those who were cleared should be gone already. So that's the risk. And I think one thing that I've said very frequently, and it's in my report, that almost without exception, every man who I interviewed said, you came too late. And that wasn't like I personally came too late, but it meant that the blue jacket came too late, that at the point where these men were being tortured, where they were being sexually assaulted by the use of forced feeding, rectal feeding, where they were subject to waterboarding, where they were subject to egregious harm, including the violation of the fundamental right to express their religious beliefs and pray. There was nobody there. Nobody was there. In fact, the US, the rule of law, there was rule by law, there were laws, but they were egregious laws in breach, I would say, of our fundamental constitutional principles in the US. And there was nobody there. So in this, they were completely right, that we came too late. Coming to Guantanamo when there were only 34 prisoners was 2 decades too late. So, yeah.
Do you think that even if Guantanamo were to be shut down and all the prisoners returned home, that the United States would ever be held accountable for what took place there?
I'm an optimist. If you're a human rights lawyer, you just have to be an optimist because there is no other choice. You just have to believe that the long arc, in Martin Luther King's words, the long arc of history bends to justice. The long arc is justice. And I am a great believer that secrets don't hold. And actually, in particular, for democracies, secrets don't hold. And I've seen that in my own conflict in Northern Ireland, where the British government, as a democratic state, engaged in egregious human rights violations. They included detention without trial, which was actually the precursor and used by White House lawyers like John Yoo and others to justify, and Bybee, to justify the detention of men at Guantanamo Bay, Cuba. But 30 years later, we're still holding the UK government responsible for those violations over 30 years. So democracies, even if it's a long term, are in my view self-correcting and should be self-correcting. And there's no statute of limitations for torture. And I sincerely hope that all of those people who ordered, instigated, collaborated, supported, legally justified, and carried out torture, that none of them will sleep very well at night. And they shouldn't travel to countries where there are universal jurisdiction statutes, because we, the global community, are watching them. We know where they are, and we are intent that when they get it wrong, we will get it right. So that doesn't get justice for these men, right? And many of these men who were wrongly captured, who were brought and tortured and then dumped back into their countries without remedy or any form of compensation. These men have incredibly difficult lives, and they are all torture victim survivors. So I think at the macro level of justice, we will do justice. But for these individual men, I think enormous harm has been done. And it's clear that some harms are unfixable. When you torture somebody, that's unfixable,
Yeah.
Yeah.
Something else that I really admire about your work is the way you always bring gender and women's rights into the conversation. And you've talked a lot about, and you brought it up in this interview, being the only woman in the room.
Yeah.
Can you speak to why that's such an important issue for you? And if you feel like since you've started your legal career, there's been progress in that area, or do you feel like we have a ways to go?
Yeah, I mean, so when I went to law school, you know, it wasn't majority women. When I started teaching at this law school at the University of Minnesota, we had a minority women population of lawyers. And I think many of us know a lot about the profession. That if we look at partnerships, if we look at the arc of senior women in the legal profession, there's like an enormous gap between the women who are now going into the profession in equal numbers and coming out not in equal numbers at the other end in terms of the sort of status of the profession. Yeah, I mean, I think I was lucky that I had extraordinary mentors, and I had feminist mentors, some of whom were men. And I think it's really important that it's not only the women who are the feminists, right? I think that in my lifetime, partly because I came into law at a point where it was predominantly male in terms of my professors and the individuals who mentored me, they were all men. They made choices to mentor a woman and to support a woman. And I think that's super important. In the area of security and counterterrorism, it's overwhelmingly male. I issued a report to the Human Rights Council and talked about the structural gender and race biases of this area of security. And the truth is, it produces terrible counterterrorism policy because it turns out when you have unrepresentative spaces that are thinking about why do we have these problems, they produce pretty ill-fitting responses, right? So the point is not we need women because we need women. It's because actually if you're going to address the fundamental and root causes of violence in a society, you have to have actually the totality of a representative group of people thinking about that. And when you have people who all look the same and sound the same, it turns out, as it's true, that we've had 20 years of lousy counterterrorism policy. Like, has any of this worked in the last 20 years would be my argument. But I think it is true still that there are very few women in senior roles, and the costs are high. To be clear, I travel a lot. I am on the road constantly. I'm very lucky that I have a massively supportive spouse, and I have children who learned that mom was going to be away and not on a phone for 2 weeks sometimes. When we were in Syria, we didn't carry phones. So I was out of contact with my family virtually for 2 weeks. So I don't want to suggest also that like the cost of being in these spaces is cost free. You're making choices, and those choices have impact on your family, on your institution. But I think the more women make those choices, the less exceptional it is that someone is in that space. Yeah.
Right. I was hoping to wrap up. You could offer some words of encouragement and wisdom for young lawyers such as myself entering the field of human rights. Right. At this point in history, specifically in the U.S., it seems difficult to muster up the strength to try and make a difference. So I was just hoping you could speak to that.
Okay. So I really fundamentally believe that being a good human rights lawyer is just you've got to be a good lawyer first, really good lawyer first. You have to master the skills of so often my human rights students will want to take every human rights class in the law school. And I think that's great. Take plenty of them. But take evidence, take corporations, take tax law. These things are really important. I'm a really good international lawyer, but I'm also a really good lawyer. And so I think those skills of practicing law, of thinking like a lawyer through a whole set of things. And often it helps you in places where you don't have a human rights solution, but you could have another solution in another area of the law that really allows you to think out of the box. So I think that's the first thing, is learn to be a really good lawyer. But mostly I would just say that I think we're in really long fights. Like and that's hard generationally, where like, I think my kids are also like, oh, this is going to happen tomorrow. And I'm like, no, it's going to happen in 30 years time. So like the fight that I'm in for Guantanamo justice, for justice on legacy issues in Northern Ireland, for surveillance regulation. That's a 30-year fight. That's not a 5-year fight or a 1-year fight. These are just really long fights. And so I think we have to change the way we think about how we win. We win over the long haul. And I think the other way we win is that we win in relationship. So I was really lucky at law school. My 2 best friends at law school are still my 2 best friends, right? And I built a community that supported me to do this work. Yes, there's your family, but you're just part of this big group of people. And it's okay to step out. Like I have spent a year post my mandate writing a book and thinking about and reading and walking and taking and understanding that sometimes you actually have to take a rest and there are cycles. When my kids were small, I wasn't on planes every day of the week. So it's also learning that if you're in a long fight, that actually you have to sort of organize your life around the length of that fight. And you will do different things at different times, but you don't have to be in the fight every single day, you know? And I think that helps us feel like less pressure about that we're somehow letting somebody, mostly ourselves, down by not being in the fight every minute. And maybe the last thing I would say is like, there's no better fight to be in. I mean, I don't see, if you have chosen law as a career and you believe in the rule of law. And I want to believe that there are many, many people in this country on both sides of the political divide who fundamentally believe in a law-based society and that is bigger than other things. And so there's just no better fight to be in. And I would say for folks feeling discouraged, start right where you are. I didn't start in Guantanamo and I didn't start in Syria. I started in my local community in Ireland doing work on the thing that was right in front of me. And some of that was reproductive rights. There was no abortion, divorce, or contraception available in the country I grew up in. And as a young woman, that was a fight worth being in. And it took us 30 years to win that fight. 30 years. But like, what better fight?
Yeah, that's wonderful. Well, thank you so much for that and for sitting down with me today. It's been a privilege to be in your classes and to engage with your research in this way. But thank you so much.
Thanks.